Hello.
Hello. Hello.
Can you hear me, James?
Yes.
All right. Well, welcome to the consultation, everybody. My name is Josh Floyd.
My name is James Palin, senior, that is.
Senior now, huh?
Yeah, that's it.
So here's the consultation. I guess we're both attorneys. We should probably tell you that at the Jimenez Law Firm.
Sure.
And here at the consultation, we just take some legal questions that people send in to us, or some people post them on Facebook. And we kind of do a quick analysis on them and kind of walk you through the thought process and kind of what we think, what goes into it, and kind of give you some things to think about. We'll say it now and in the middle, and then at the end, we're going to say it again, right? Do not take this as legal advice. We always advise everybody that if you do have a family law or a child support issue, go to an attorney that practices family law or in the jurisdiction where you live or whatever court it is that your case is in, and get their advice, because it differs greatly between jurisdictions, and it's really helpful to have somebody from that jurisdiction that really knows what they're doing. Follow us on all social media platforms. Our guy Keon is amazing, and so we are everywhere except for the dark buses, now that I think about it. But give him time, he'll fix that, I'm sure. So Facebook, LinkedIn, TikTok, Instagram, Twitter. Is that it?
Yeah, I think you said them all.
Okay, well, any social media platform you can probably find us on. So we ready to roll? James, got anything?
Yeah, just excited to be here. It's Friday. Exciting.
It is Friday. It's been a heck of a week for sure.
I agree.
Although you'll notice Miss Jimenez, typically she's on here with us. She's not here with us today. She's on vacation, right? And so that's made the week a little smoother, right?
I don't know about typically. Typically I'd say more times than not she's on, right? Or no?
I think so. Yeah, I think so. But here recently, it seems like she hasn't been on a lot.
You know.
Yeah, this vacation thing, she's really taken full advantage of this summer.
Yeah, wish her and her family well out wherever they're vacationing.
They might be listening to us right now from Italy. I think it's like 6 p.m. over there now.
That's what I'd be doing if I were in Italy. Definitely checking out the Facebook Live.
All right, you want to get us started?
Yeah, let's do it. So question number 1, father's parental rights were terminated, but still remain, he still remains on the birth certificate. What rights does he have? Father's rights were voluntarily terminated and granted by the judge. The order granting termination states, it is ordered to amend the birth certificate to remove the father's name. However, I ordered my child's birth certificate a year later and he still remains. Does he have any right to my child? Can he request to reverse the order to terminate? What you think, Mr. Floyd?
Okay, so first, I guess we'll talk a little bit about voluntary relinquishments, right? Which is what they're talking about here. So a parent can sign an affidavit of voluntary relinquishment, which basically gives up all of their parental rights to the child. Just because you give it up doesn't mean your rights are going to be terminated. The other parent has to agree, and the judge has to find that it's in the best interest, but most of the time that's prearranged before you sign. But once you sign an affidavit of voluntary relinquishment, you have 10 days to rescind. There's 2 different ways you can draft it. You can draft it to where you have 10 days to rescind. If you don't rescind before the 10th day, then it's binding and they can move forward with the termination at any point. The other way is something like 60 days. Like it's valid for 60 days or something like that. I don't remember. But anyhow, so once you get an affidavit of voluntary relinquishment, you can get an order for termination. Once your parental rights are terminated, they are forever gone. You no longer have any rights to visitation, rights to make decisions. All of your parental rights are gone forever. So to answer her question is, does he have any rights to the child? No, his rights are gone forever. He can never get them back. And can he request to reverse the order to terminate? That's a tricky question.
Yeah, I guess it depends on how it was drafted.
Yeah, so he did voluntary relinquish in this case, and going on the assumption that the relinquishment fit all the criteria that's set forth in the Texas Family Code, because it's very specific the way it's got to be done for it to be enforceable. So assuming that was done and all the proper procedure was followed on the termination, no, he cannot reverse the termination. But her problem is the amendment of the birth certificate. You have anything to add? Do you have something to say? You're sitting there like, I want to say something.
Well, I was curious, and I don't know if we touched on this last time I was on when we talked about terminating parental rights. Do we ever talk about whether the child has been born or not? Right? Because there's the what's called the waiver of interest. What if the child wasn't born when he decided to terminate his rights? What bearing do you think that would have? I just know we haven't touched on it, and I've always been curious.
So you just want to show everybody that I don't know what the hell I'm talking about? Is that your point?
No. Well, I'm saying, okay, because here's my issue. We don't know how the document was drafted, and we don't know when he gave up his rights. So it might not have even been a voluntary relinquishment. It could have been a waiver of interest.
Well, so the judge could not terminate the parental rights until the child was born, right?
Okay. Oh, yeah, okay. So you can waive your interest before the child's born, but you can't terminate your rights. Gotcha.
Correct. Yeah, the judge can't render any orders with regard to a child until the child is born, which is sometimes frustrating for fathers, right? Because if they know that's their baby, they don't have a right to be in the birth room or to see the child at the hospital or anything until a genetic tests are conducted. So
even still, we got to the hospital and I was considered a guest with no right.
Really?
Yeah, even after they blamed it on COVID, but I really knew what it was. You know.
Did I ever tell you my story when Kason was born?
No.
Yeah, it was hot. So, there's at least back then it was 8 years ago, there's a place on the birth certificate information or whatever, where the mother can elect not to add the father to the birth certificate. Dad doesn't get to sign it. Dad doesn't have a say. Mom just gets to make the decision, right? And so I was a little irritated about that.
Yeah, that's crazy.
Yeah, I was a little irritated about that. But when my wife was in the hospital, I was going to work and taking care of business and all that other stuff. So we had another kid. And so I wasn't in the room 100% of the time. Well, when I wasn't in the room, the doctor would come in, update her, whatever, right? Well, one time, the doctor came in and I was sitting there with Kason and my wife was in the restroom and the doctor wouldn't talk to me until my wife was there.
Wow. Like, I mean, sorry, Mr. Floyd, I won't speak with you until your wife's here, or completely ignored you.
Need to wait till mom's here. I was quite pissed.
Yeah.
Yeah.
Yeah. 3 lawsuits later, that's good.
Yeah, I wish. I got on a rant and it was a whole big thing, but
Security, Security may or may not have escorted you out the building that day.
Yeah, it pissed me off.
Right.
So anyway, sucks for dads. That's the point.
And
anything else on that?
No, I think we did a good job on that one.
Good. Yeah, I think we nailed it. We nailed it. All right. So will he come back? And what do we do when he does? So my stepdad and mom just got into a very heated argument and they have been married for 18 years. Every time they argue, he breaks stuff. He thinks it's funny. She just told him to leave, but we know he will come back. What do we do when he does?
And this is a rare moment because I usually don't advise this, but you can call the police. Sounds like this guy is bad news. Likes to break stuff, get violent in the house. You're gonna want some protection for you and also for your mom. I mean, the police haven't been here, I'm assuming. And once they get there, you can go ahead and get all types of criminal charges and protective orders started. But in the immediate, yeah, I'd call
What's the criminal offense?
assault,
How so?
an offensive touching, apprehension of an offensive touching. You throw
They
something.
didn't say that he hit anybody. He just breaks stuff.
Yeah, but when you break stuff around somebody, there's an apprehension, I'd argue, that you know, somebody's next. That's why people punch walls right next to people's faces, slam their hands on desks, all the stuff y'all did when I interviewed here. I'm just kidding.
So like a threat, kind of?
I'm going with assault because when you break stuff around somebody, there's an apprehension of harm, of danger, you know?
Okay.
At least that's what you tell the police.
So what if the police says, I don't think it's a criminal offense. I'm not going to arrest him. Then what?
Then I suggest, hey, mom, I think we need to move and you might need to stop seeing this guy for a little bit. Other than that, I mean, what recourse does, I mean, it sounds like a kid or maybe an adult child living in the home.
Yeah. So generally speaking, the officer won't, well, I guess the officer can't make somebody leave the residence, right? Because it's both of their house. He can usually entice somebody to leave by saying, if you don't leave, I'm taking somebody to jail.
Right.
But yeah, like James said, right, just get out of the relationship, you know, lock the doors and roll out. But what if there had been family violence? What could she do?
Right, and then we're talking about protective orders, right? When you can prove that, it's not going to be as difficult. Floyd is our resident protective order specialist. But that's when you can go in front of a judge and you can get some orders to keeping this person away from you. And those will last until the point where you have ample time to get out of the relationship and find yourself with support and safety.
Yeah, so you could do an ex parte protective order, right? Do an emergency one where the judge would issue it without a hearing. And then after that, you would have a hearing on it. And if you can establish that there is a history or pattern of family violence and a future threat of family violence, then you can be granted a protective order for, generally it's 2 years. That's the standard, which would keep him away from both of you, because you could do it. She could do it for herself as the spouse, and she could do it for members of her household as well, the child. And I guess if it's bad enough, right, if there's a clear and present danger, and you can establish that in the affidavit that you attach to the application for a protective order, then the judge can do a kick-out order, which says he can't come back into the house until you have a hearing. Those are pretty hard to get. We don't get those very often, the kick-out orders.
I don't know that I've seen one.
Yeah, we don't get them very often. There has to be a clear and present danger in order to get them. So, anywho, anything else on that? Anything else you want to talk about on protective orders? Family violence, bad. Don't do it.
Yeah. And if I'd hide your toys if you're young, you know, keep the PlayStation in the closet, maybe invest in some, you know, disposable plates.
Break them then.
Exactly, right? That's the point.
Yeah.
That's the point.
Okay. Or tell your mom to find a less aggressive, temperamental spouse.
Right. But how often do parents take dating advice from the children? You know?
Not frequently enough.
Okay.
Not frequently enough.
Yeah. Good. All right. What you think?
Yep, let's roll on. You reading?
Yeah, I'm just scrolling past what we just did. Okay, here we go. Is there a limit on the number of times the other party can request an extension? My husband is currently fighting for custody of his daughter. He discovered the lady he had been seeing at the time is married, and because of that, he has no paternal rights to his daughter. The court requested him and the other party to get DNA tested, and they keep requesting extensions. Is there a limit on extensions? Sounds like one of our cases.
Yeah, no kidding. Wonder what county this is from. Maybe we should
We might be conflicted out of this answer.
Since we're going to presume you're from like Harris County, where we don't have any active cases right now, we'll answer. Is there a limit? Yes. So the limit is whatever limit the judge puts on it. So continuances are up to the judge to grant or deny. Generally, if the attorney has a good basis for requesting the continuance, you know, a vacation letter, a conflict, just got hired, whatever, something's going on. If you got a good basis, judge will generally grant them. If you don't, judge will generally deny them. But I don't really know why that's holding up genetic testing unless they're fighting it, right? Because as a part of the continuance, judge could order genetic testing and be doing that while you're waiting on the next date.
Maybe they're talking about extensions on the DNA testing and not necessarily a continuance. You know?
Oh yeah, because it says the court requested him and the other party to get a DNA test. Yeah.
But to your point on the continuances, I feel like 2 is, I can't speak for every county, but usually 2 is right where judges start to be like, all right, look, now you've had 2, let's move this thing along. Has that been your experience?
It is. Most courts will give you one free one, absent extraordinary circumstances. Most of them will give you a free one. Everybody gets a free pass. But the number 2 one, you better have a good reason. And number 3, it better be a damn good reason.
Right. Yeah. Yeah.
What was I going to say with the genetic testing? So this is a sticky situation because he got a girl pregnant that is married, right? And so now her husband is the presumed father because they were married during the birth of the child.
Man.
And so he has to, the only way that you can rebut the presumption is if father, bio dad, signs acknowledgement of paternity and presumed dad, i.e. husband, signs a denial, or with genetic testing. I think it's just one case that I've had where the party was ordered to do genetic testing and then just never would appear for the genetic screens. And so we could never move forward. But there is a provision in the code that says if they fail to comply with genetic testing, the court can render on it and adjudicate them the father regardless.
Yeah.
So that's an option, but it sounds like they probably both have attorneys. And if the court's granting extensions, there's probably a good basis for it, or at least the judge thinks there is.
Yeah, that is a tough situation.
Yeah.
So your husband, yeah. And so that guy is Yeah, the presumed father. You know, and it's funny, we were just talking about Maury before we got online. This looks like a classic episode.
Yeah.
Okay.
So it's her husband. So did he have an affair on her, or is the child older?
See now, Floyd, you're reading too much into the question. You know,
Well, because we do have that statute of limitations thing at 4, right? And so if he had a child with this lady and is fighting for custody 4 years later, or fighting to be adjudicated the father, right, then he may be barred by the statute of limitations, which may be part of the delays.
Right, and I see what you're saying, because he's had time to get over that woman and court and date this other woman, and propose, get engaged, get married.
Right.
So.
Either that or they both need to bounce.
Yeah, this is an interesting one. The timing on this is going to be very important to look at.
All right. I'm anxious for this question. You ready? My husband committed polygamy.
Is that in the code?
I wasn't sure. I married my husband in 2003. He married someone else in 2007. And then another woman in 2013. This guy's lost his damn mind. Wow. I can't do one in life, much less 3. I just found out, just kidding, love you, babe. I just found out about this. We are in the process of a divorce, and he wants half of everything I have. What can I do?
What?
So the process of a divorce, so she would, if we divide it into quarters.
No, those other marriages, right? So, and I forget the term of art, but those marriages are invalid. Yeah, because you were married. So unless you can show, I mean, you can show he cheated on you. So, I mean, you're looking at disproportionate share. I think that's one route you go. At fault divorce due to infidelity and fraud and all other type of craziness that he's involved in. But with regards to the other women, I don't know that their sham marriages affect you other than that he's been unfaithful, because you are the first wife. Now, if they were filing for divorce, they'd have some issues because legally they could not have been married, because in the state of Texas, you can only marry one person. So maybe your husband forgot he was in Texas, wanted to go live elsewhere. Are there states that it's still legal?
I don't think so. There are some religions that recognize polygamy, but I don't think it's state sanctioned.
Hey, well, not mine. But the other thing, yeah, the other thing, how you went about finding all this stuff out, or maybe he was trying to get you in, that's another story. But I think that's your best route, going for the at-fault divorce due to your husband being a creep.
Yeah, so the last 2 marriages are void, right? Because you can only be married once, right? So you can't get remarried. But let me throw this at you.
Okay.
I think we've talked about this before, but the punitive spouse, right? So let's say the person in 2007 didn't know he was married. They bought a house together, $500,000. They spent community funds on it. Didn't know he was married, right? So now does the 2007 spouse lose out on all of that because it's technically community property with the 2003 spouse? No, and then God forbid we do the same thing with the 2013 spouse.
Sorry.
If they're all punitive spouses, you could have a real mess on your hands.
Yeah, that's sounds like a bar question. That's horrible. And I'd have to do some more research to find out their remedies, because, you know, they're an innocent actor in somebody else's wild love triangle?
So if there were only two spouses, so one real spouse, one putative spouse, it's easy, right? They each get 50%. Husband takes nothing because he's the one that committed the fraud, right? But you have three, and they all three can't get 50%, which is what each one of them would be entitled to as a spouse and the putative spouse, unless he has 150%.
Right, which is what I try to give every single day. Yeah, the love triangle, that's where it gets tricky.
Well, this is a square.
He's got 3 wives.
Well, in him, that's 4.
Okay, all right. All right, so you're good at geometry. All right, touche, Mr. Floyd. Okay. Yeah, that'd be interesting.
Yeah, so you're in the middle of divorce. What can you do? Fight. Hire a good attorney in your area, because you don't want to take this as legal advice, right? You want to make sure that you hire somebody in your area that's familiar with the courts, that practices family law, that's very experienced, especially in this case, because this gets into some of the real intricate details of family law that aren't very often litigated. So yeah, hire somebody and take 100%. And ask me one of the putative spouse's names so I can intervene and try to get my hat.
Right. Hey, husband to move out somewhere, man. He's got a lot of love to give people, which I'm not mad at him for, but he's got to do it in the proper venue.
Well, divorce is expensive. You can get married a hell of a lot cheaper than you get divorced.
I don't know. Weddings aren't cheap either.
Yeah, he probably didn't have, there's no way he afforded 3 weddings, right? Maybe the 2003 one was a wedding. 07 and 2013, they went to the JP. $75, whatever it is.
Say, man. I'm not mad at him. Just do it in the right venue and let people know, you know. Let them know up front. Interesting question. Thank you for that.
Well, but what if they were common law married and he didn't realize he was married?
Well, they'd have to prove a common law marriage, which is they had to be living together, and they had to have an agreement and put out into the community that they were married.
Yeah, so him and the 2003 spouse
living together
are common law married, but he doesn't consider them married because he's not familiar with the elements of common law marriage and how that works. And so he gets married in 2007.
And I think he debates this whole divorce. Hey, we're not getting divorced. I'm just leaving, right?
But if she can prove the statutory elements for common law marriage, then what?
Then he screwed out of half his stuff. And his other marriage, let's just say he's not married in 2013. That marriage will have to be void. And she'd be effectively, wait a second, how could he be married and living with the other movement? All right, see, there's too many variables in this.
No, okay, so him and this woman get together in 2000, right? They live together until 2005. In 2003, they start filing taxes together as married. She's wearing a wedding ring. They satisfy all the elements for a common law marriage. 2005, they split up. He's like, cool, we just broke up. I meet this chick in 2006. I marry her in 2007, formally.
Okay. And you're saying if early wife files for divorce saying, hey, we were married, common law married, half your stuff is mine, what effect does that have on, yeah, I mean, that's what it is. The 2007 marriage would be void. You can't be married to 2 people. You have to get real divorced, even if you're common law married.
Yep, there is no common law divorce. But then isn't husband and 07 wife now putative? Like neither one of them committed fraud intentionally.
Yeah. So in that same example, yeah, you really have to do some mean litigation work, or just really argument. Hey, judge, my client didn't know he was married. He's not an attorney. Giving 50% of his stuff to wife A and 50% to wife B, leaves him with nothing. Have a heart. And then
Oh, they'll have a heart argument, huh?
see, it's,
You gotta be careful which judge you argue that to. Some of them don't have them.
I don't believe that. Not any judge, all judges need this same red fluid I keep in my veins. But yeah, it goes back to that pathos, logos, and ethos.
Oh shit.
Yeah. That's right. We're going back to it because you made me look like I was crazy. But people of Facebook, it's a real thing, and these are tools of persuasion that you can use in most situations. Just pick the right one.
I guess the real question is would the 07 spouse have a potential IIED claim?
Right. Right. I don't know about intentional. Actually, yeah. I mean, I say go for it. I got to do a little bit more research on the tort law piece of it, but it's in the law, and you may or may not have remedy. Consult with your local attorney. Follow them on Facebook, Instagram, TikTok, and all of the social media avenues.
Okay, have we beat that question dead? Do you think we answered her question, or do you think she's confused as hell right now?
No, absolutely. I think we got to the bottom of that, rose to the top, and then sent it in the direction it needed to go.
Good.
I think we're having too much fun now. We took that constructive criticism too literal.
Yeah, and when Christina's not here, we get to have more fun.
I don't know about that.
Yeah, maybe not. It's more work.
Right. You had that.
I'm used to having to take up her slack anyway, so it's not such a big deal. So on that, we'll move on to the next question.
I'll read it. Yeah. Can your spouse take your deed while in process? Wait a second. Can your spouse take your deed while in process of a divorce? I filed and he said he wanted to take me off the deed before we go to court. We both lives under that roof with our 4-year-old son. This isn't possible, right? What do you think, Lloyd? Yeah.
You know the next question?
Well, you're going to talk to about what is it, the quitclaim deeds and
oh yeah, we can do
what have to happen.
Okay, yeah. So let's talk about deeds. So in this case, there's two different ways this could have happened, right? One is they bought a house together, both their names are on the deed, right? He can't remove your name off of the deed unless you sign a deed, either a general warranty or special warranty deed, deeding him your interest in the property. So he can't just go like erase your name and file it and be good. The other way this could happen is if he had the house before you guys got married, and then he added your name to the deed later, right? Same thing, right? You still now have an interest in the property, and he can't remove your name without you signing it over. But I bet you didn't know that you have two different interests under the two examples that I just explained. I would poll the audience, but there's no way for them to like tell me whether they knew the answer to the question or not. So I'm going to presume.
All right.
We should do a poll. Keon, give us poll capabilities.
Okay.
So under the first scenario, when they got married, both names put on the deed, it would be community property. Whether or not both names were put on the deed wouldn't matter. It's still community property. It was purchased during the marriage. Under the second scenario, where he had it beforehand and then added her name to it, it's now both of their separate property. So the law says that he then gifted her 50% of the property. A gift is not considered community property. So they each own an undivided 1/2 interest in the property as each of their own separate property. Either way, it's a long way to explain this, but no, he can't take it off. Court will deal with it when you go to divorce, and certainly don't sign it over to him. Although I can't give you legal advice, but if I were an attorney that practiced in your area and that specialized in this type of law, I would strongly advise my client to not sign anything over until they spoke with somebody as intelligent as Mr. Craylin here that would give them good advice.
That's it. All right. Now I think that question has been grilled to a well done temperature.
Awesome. That was my goal. Okay. Should we skip to the next question?
Which one is that? Can you help me understand what an exclusive? Yes.
You don't want a Webster exclusive?
No, thank you.
How quickly can someone help with a non-contest divorce? The issue is that the husband is located currently in the UK, that's United Kingdom, and the wife is in the US, that's United States.
Well, I mean, it's really not gonna matter where he's at. How long have you been in? Well, I'm not just gonna assume you're in Texas, but I mean, service could be an issue, but at the same time, if y'all don't have any children, you can still get divorced. 60 days, Texas.
Yeah, in Texas. So where it becomes a problem is if there's property. So a court can grant a divorce if one of the spouses meet the jurisdictional requirements, right? 6 months in the state, 90 days in the county. But if the court doesn't have personal jurisdiction over the other party, so for example, if the other party's never lived here, didn't consent to jurisdiction, wasn't served in the state, there's numerous ways you can get personal jurisdiction. But if this guy's been in the UK, never been in the US, he's never consented to jurisdiction, unless he filed an answer, but I'm gonna assume he didn't file an answer. So he didn't consent to jurisdiction. Then a court can't put any obligations on him. Can't divide any of his property, anything like that. They can grant the divorce. They can divide the property that's in Texas because they have jurisdiction over that property, but they can't order child support, spouse support, division of property anywhere else or anything like that. So how quickly can it happen? So non-contested, they're going to agree, right? They're both going to sign. You're not going to have jurisdictional issues.
Yeah, so I say 6 months. Not 6 months, 60 days. I'm sorry. Friday.
So do you know why the state of Texas has that 60-day requirement, James?
Well, 60 days is a good amount of time to consider your options. I don't know that that's what the state had in mind, but I figured it has something to do with the institution of marriage and not wanting people to just jump into their new state and file on whoever, whenever.
Yeah, no, you nailed it. Good job. So it's called a cooling off period, right? So that way you don't impulsively get a divorce because you know you still truly love that person, even though you're angry at them, and you'll refine that love. It'll reignite within that 60-day period. And if it doesn't, then get divorced. But that's why you have to wait 60 days.
Yeah, and actually, that's a little romantic, even, you know.
I've got a little of that in me.
Respect.
Do you know the exception to the 60-day waiting period?
Family violence.
Yeah, I want to say there was one for like military also, but I'm not sure. Maybe that's just with marriage.
Wait a second.
Like if they're about to be deployed. I know that like if you're trying to get married, you can wait the 72 hours if you're about to be deployed. I don't know if that applies to divorce or not. So.
Oh yeah, that would be horrible. Yeah, well, you know, so-and-so's in the Army, so you can cut them loose early. That's crazy.
Well, if he comes in and says, hey, I want to get divorced, that way, if something happens to me over in Afghanistan, this person that I don't want to be my wife anymore doesn't get my badges or medals or whatever. My remains, because she may be really mad at him and you don't know what she's going to do with them.
Yeah, I wanted a burial. I got cremated. I got you.
Yeah, I don't know if that's an exception or not. So, but it doesn't really matter because this isn't legal advice anyway, right? We're just kind of BSing.
Don't forget to follow us on Facebook
And TikTok.
and
No, you're up, right? Who's up? I don't know.
yes, yeah, that's me. I'm contemplating divorce and would like to know the overall process of how that works. What's the first step in the process? A starting point would be separation. Not sure what that means though. Length of time it may take, possible costs, etc.
Holy crap.
The clip notes. Yeah. Give them the rundown, Mr. Floyd.
We spent 2 hours on this question.
We only got 19 minutes, sir.
Okay. So in Texas, there is no such thing as a legal separation, right? Texas doesn't recognize it. If you're living apart, well, whether or not you're living apart. So what we do in Texas is we have temporary orders hearing, which is basically the judge will render orders, with regard to conservatorship, possession access, child support, if you have children, medical support, that kind of stuff. If you don't have kids, then it'll just be the property stuff, who gets to use what property, who's responsible for what debts on a temporary basis. And then what they award is, they call it the temporary exclusive use of, right? So it's not being awarded to you as your property. You're just getting to use it right now while we finalize the divorce. So that's, I guess, what Texas does for their legal separation, but it's not really, I mean, you're still married. You're just under temporary orders, but it kind of controls I guess it dictates the term of your separation.
Right. But we've also seen clients get in trouble for dating folks and getting people pregnant and buying houses. And so you're still married in every sense of the word.
Absolutely. It would still be adultery.
So, but no, please continue, Mr. Floyd.
Thank you. So after temporary orders, it just opens up everything, right? I mean, it depends on what your goals are, what the outcome of the temporary order hearing was. You may need, discovery, which is a process where we can gather evidence. You may need depositions where we can ask questions to people. You may need mediation. We may need investigators. We may need property documents. I don't know. I mean, it could open up a whole gambit of things. And that's why it's really important to hire an attorney that's experienced, because they'll walk you through the strategic advantages to each one of those paths and kind of guide you in the right direction of which way they think you should go. And, the most cost effective way to do it, to achieve your goals. But a lot of times, I don't say a lot of times, sometimes clients don't listen to us and they get to make their own bet. So anyway, after temporary orders, you go through whatever you're going to go through, and then you either get to mediation and you settle at mediation, which mediation is a process where you can come to an agreement. You have an independent third party who is a mediator, a licensed attorney, generally within the jurisdiction where your case is. They help you settle the case. If you settle at mediation, then you just go to court and tell the judge what the agreement is, and you're divorced. James, you finish. I'm sorry.
Are you running out of gas?
Yeah.
Get a Gatorade or something. You're so close. Okay, in worst case scenario, you do not find an agreement in mediation. And then we're headed to a final. And that's where, the gloves come off and, you hire your experienced attorney out of your local county or city, and they go to bat for you. They argue conservatorship, child support, the whole gambit, whatever you're looking for. That is the proving ground. I can tell you sometimes, relationships are tested and there are long-lasting effects from some of the stuff that comes out of, you know, testimony in the final hearing. But that's not to say you should be weary or afraid or anxious, because when you hire that experienced local attorney, they'll be able to concoct a legal strategy best designed for your success.
Yeah, so I tell everybody that avoid litigation if you can. Now, for my purposes, I would rather litigate than negotiate, right? I mean, that's what we love. Negotiating is not near as much fun as litigating. But when we go into the courtroom, you know, go ahead, James. You got something?
I was just gonna say, for the people involved, you know, if folks are crying and say, "Oh, you cheated on me, beat me up in front of all these strangers," you know, probably not as fun for them.
Yeah, and we go in the courtroom. I tell my clients, like, it's my job to make them look as bad as I can, and it's their job to make you look as bad as you can, or as they can, right? And that's not fun, particularly if you have kids and you have to co-parent after that, after you just drug everything out of the closet and do it out in public. And my wife and I was actually discussing this last night. I don't remember why we got on that topic, but we were talking about it last night. It's just, it's hard to do. It's hard to co-parent after you have let all those skeletons out, because you trust your spouse with very private, intimate things, and it's thrown out very publicly.
Yeah.
Not any fun for the clients. So try to mediate if you can. That's what that boiled down to. Length of time, James, that's her third part of her question, or whatever it is.
Length of time, how long does it take?
Yep.
Well, 60 days at least. Or as far as the hearings go, I mean, those can take, you know, 4 hours, you know, really, or 8. Yeah. Yeah. They can take all day. It really just depends on the facts of your case. All that you are looking to garner through divorce. If you got kids, a whole bunch of property, if there's family violence, if there's adultery, if, you know, your spouse has been married a few other times, you know, all these things you want to take into consideration, because your time is worth something, right? We've seen divorces go on for years. Floyd, you had a couple of those cases.
I got one now. I think it's been pending like 5 years.
Right. So now, you know, sometimes the kids are grown now. You're not even talking about child support. So what are you doing? Right. So it's, you want to think about those things before you want to call.
James, they're lining our pockets.
Right. But there's other ways. Yes. Yeah, that's true. But Floyd, all right. At the same time, you said you can always go back and find love. So which is it, Mr. Floyd? Which is it?
You can find love while lining our pockets.
Right. And we do all types of adoptions and, you know.
Yeah. Oh, seriously though, when you fight like that, we're the only person that wins, right? It would, you know, you spend thousands of dollars, and
yeah, y'all aren't going to believe this, but Mr. Floyd has a pair of ostrich boots, at least $7,000 to $8,000 every time he touches them, and he only wears them once and then throws them away.
And you should not believe that.
Every single hearing.
Yeah, so they can go on for years. It just depends on, like I said, the crap in your case, how difficult each of you are being.
Yeah.
Possible cost?
Whew. Possible cost. You really want me to do the rest of this? Okay. Because this is the uncomfortable part. I mean, you can spend a lot of money, a whole lot of money. 50, 60 grand. And that's not even the worst I've heard, but that's the most I'm comfortable sharing on Facebook Live.
So I think the most we've ever had was pretty close to 150,000, if I remember correctly.
Eesh.
Foolish. And that was just our client, right? They had counsel as well. And so, yeah,
It gets scary.
it's crazy. It's crazy. But But so I think the cost really is, I mean, it depends on how good of an attorney you want. Right? I mean, you can go out and get a bargain attorney, and I think they have, buy one, get one stuff going on or something.
With divorce.
Well,
I don't think
hire me on assault, family violence, to represent you on the divorce for free or something, right?
Okay. Man, that's actually not a bad marketing employee.
Someone's going to steal that now. Yeah, no, I mean, there's attorneys of all skill levels, and they're priced accordingly. So you could, I mean, I think there's people out there that are doing divorces for a couple $1,000, $2,500. So
wow. Yeah, so that's a huge range from 2,500 to 150K. So find yourself somewhere in the middle. I mean, maybe you're doing okay. What do you think about the et cetera piece?
So et cetera means I don't know what else to talk about. They didn't know what else to ask about, probably because they asked all the questions and we've covered every possible thing in a divorce.
Okay. Well, I thought maybe you were talking to like some of the fallout effects and, communication, co-parenting, that sort of thing.
I did not, no.
Yeah. Good question, though. Good question.
Was it really?
They got a lot. They got a whole lot with not a.
And they didn't pay for it, but it wasn't legal advice, so it doesn't really matter. We're just talking.
Exactly. Okay. I think
what happens if I get the charges dismissed? I haven't been indicted and it's been a year, but I'm out on bond. My court-appointed lawyers says if we file to get it dismissed, then they can come back and indict me and take me back to jail since I won't be out on bond anymore. Is that true? I don't know if this falls into the realm of family law. We're gonna talk to our question screener about this, but I get it. We just do some criminal law too, right? Right. Taylor's the criminal law master, so give it a go.
Okay. Yeah. So this is going to depend, and it's funny how you have to remember this. I remember in law school, prejudice is actually good, and without prejudice is actually bad. So if they dismiss without prejudice, then they can come back and, charge you for the same criminal episode and throw you back in jail, and things will be bad for you. But with prejudice, then you're in the clear. So your lawyers, how you have multiple court-appointed lawyers, you must have been something pretty heavy. Yeah, they're not lying to you. And since you're looking to be indicted, looks like you're staring at a felony, you're going to wait a lot longer than 1 year, okay, for your statute to run. So remember, and the way I remembered it is, these laws were made by a lot of old folks a long, long time ago. So back then, prejudice was good and no prejudice was bad. So that's how you got to remember it. Mr. Floyd, what do you think?
So this is a question that always comes up, not always, but frequently comes up in our criminal cases, right? Yeah. Where they haven't been formally charged, the statute of limitations hasn't run. Do we make a move? Do we sit and wait? I generally default to sit and wait, right? Because generally in criminal cases, the longer it goes, the more evidence gets lost, more witnesses get lost, or recently officers commit crimes,
right,
and really blow your case out of the water. So it really just depends, I guess, on the charge and the conditions of your bond and that kind of stuff. But I generally default to waiting because your court-appointed lawyers are correct. Like James said, if it gets dismissed, it doesn't mean, first of all, it can't get dismissed, right? Because there's nothing filed. Right. So I think his only remedy would be a writ of habeas, saying he's unlawfully restrained by being placed on bond. Or he could do an examining trial where he could go argue that there's not probable cause for the arrest, which probably will lose on that. So,
And it'll draw a whole bunch of attention to your case.
yeah, you can piss them off.
You know, no real reason to do that. And honestly, coming into the game, that's how I was. I wanted to file everything I could. The first day I could file it. And, you know, it took, you know, the wise words from, you know, a few local and experienced attorneys to let me know, hey, man, sometimes you don't want to shake the tree because a snake might fall out.
Those are very wise words, James.
Yeah, you know, sometimes I just freestyle it and they get in there.
Okay. Is that it? We're good to go? I think the next one's too long.
Yeah. And I don't know if that's a family one either.
No, it's not. Cool tools. All right. So I'm going to put up this disclaimer. I think we nailed this not legal advice thing
Oh yeah.
episode.
There's no question that we're not giving legal advice out here.
Yeah, there's no question. So in case you missed it, the 15 times we said it throughout this episode of the consultation, nothing we said here today was to be taken as legal advice. Just roundtable talk, going over some issues. If you have a case, you know, you need to hire somebody that's familiar with the judge that your case will be in front of, that's experienced with the issue you have, whether criminal law, family law, or whatever. Hopefully we've given you some things to think about and talk about and maybe laugh about. Some of these stories seem pretty outrageous. These are day to day for us. So yeah, it's just, this is normal, but some of them get pretty crazy. So hopefully you've got something to think about. And if you do have an issue, you know, go hire you a good attorney. Anything else, James?
I just want to commend us on a job well done today.
Yeah, so I was gonna let you finish off with the follow us, but you missed the cue.
Oh yeah, I mean, of course, you can follow us on social media. I mean, that goes without saying. TikTok, Instagram, Facebook, Snapchat. Well, I guess pretty soon we'll be on Dart and Greyhound and Megabus.
All right. Well, I guess that's it. Have a good weekend, James.
Likewise.
Doodles.